out of the total 3,500 petitions which have been adjudicated by USCIS, about 97%, which is 3,442 of them got approved only, and only 3%, which is 113, got denied due to genuine reasons, of course. Do you see this as a positive sign of continued investor confidence in the EB-5 visa program? And what could be the reason these 3% of applicants got denied?
Yeah. That's a very good question, first of all. I would like to compliment and credit the success of this to both the regional center councils, regional centers as stakeholders, and predominantly the lawyers. Because I think as immigration attorneys, we have to do so much amount of groundwork before we even give a green light or a signal to the client to go ahead and wire the funds. As immigration attorneys, we have very set standard that we would not give you a clearance to fund unless your documents are in consonance with the USCIS evidentiary requirements. We just discussed in the earlier segment of the podcast about staggered payment, and I want to add that segment here because it's very critical to know. First of all, your $800,000 as per the regulation has to be lawfully earned, legally traceable. All of that is fine, but how do you prove it to the government? And as lawyers who've had decades of experience in dealing with EB-5 applications, we have checklists which are prescribed. We talk to the clients, we consult with them, we caution them ahead of time of the risks involved with strategizing that source of funds, and then subsequently come down to a consensus that, okay, these are the strategies that will work for you. We look at the documents, and once Rohit, Ignacio, myself, we are convinced internally after our strict due diligence, do we then give a go-ahead to the client to wire the funds? So I would like to say that if the denial rates are low, as per the data, it would be because of incredible work with source of funds. Also, USCIS is approving the business plan applications in a record time. I've seen the range of approval timeline to be anywhere between 3 months to maybe a year. And unless your 956F business plan application is approved and your source of funds are qualified, you cannot have a positive outcome on your I-526A application. Going back to the topic of staggered payments, please do speak with your immigration attorney before you take the decision of staggering your investment schedule. Regional centers are very accommodative these days because you would like to meet the timeline and lock the priority date. And this is also critical because for families who are aging out, having that priority date in place is very, very important. Having said that, we've had sleepless nights over the last 3 to 4 months because we've seen a heightened scrutiny of the government on staggered payment cases. And currently we see that the government has a very high standard of proof required on these cases. You need to be able to prove to the government on the date when you're filing the initial petition as to what would be your anticipated source of funds. Not in entirety, but you need to have a roadmap. You also need to have some sort of corroborative evidence submitted so that your case is eligible to be approved when filed. And this is being interpreted in law. This is not me saying it. And Rohit and Ignacio can add on to this. So confer with your immigration attorneys. Make sure that if you have to take a decision out of financial constraints to stagger payment, you have a roadmap for the upcoming source of funds. And just do a good job at your application because this is key to success. Coming back to the data, if there have been denials, again, I would say that there could have been source of funds issues. We also have seen the government very strict on currency exchange matters. So for countries where you exchange your local currency into US dollars, keep a complete trail of all the documents. If you've not kept that, maybe that could have been the cause of denial.
Great. The next question that I'm going to...
Before you jump on to that next question, something that Aarushi said, very, very important. I just want to stress what she said in terms of the investor discussing with the attorney and identifying the roadmap where the rest of the monies are coming from. That's been a requirement forever and ever as far as I can recall. And I tell the investors, you have to know where the rest of your money is coming from, and you cannot change that source because you're immediately going to have a negative impact. So I just wanted to stress for the investors that what Aarushi said is very, very correct. And those 113 or 130 denials, let's not forget, maybe many of them are being appealed. So that number may be out. It may be, not quite exactly that number yet. Though I think Ignacio would probably agree that it seems as if the appellate bodies are rubber stamping the denials. So maybe that 130 will stay at 130. I don't know.
I think in relation to staggered payments, one of the new trends that I would highlight to your audience is the idea that the U.S. Immigration Service is applying quite strictly the source of funds concept to future investments. So just to be very clear, you have to provide source of funds for the money that you actually invested into the target company called the new commercial enterprise. And you have to provide as detailed as possible source of funds of the future amounts that you intend to contribute to the company to complete the $800,000 capital investment. And this issue has turned into a very pernicious issue in as recently as July of 2025. And we started seeing a new trend by the Immigration Service to take investors to task over this particular matter. And
Absolutely.
frankly, I would warn the public that they need to be very careful in relation to that. Another trend in relation to this issue of staggered or deferred payments is that the U.S. Immigration Service is requesting that investors that pursue staggered or deferred payments, that they provide active evidence at the time that they're expected to finish their investment of the completion of the capital investment.
Correct.
So if you, on the application day, you say 6 months from today, I will finish my investment, the government is marking the calendar 6 months from today, and they want you to actively deliver to them the completion evidence of the finished $800,000 capital investment.
Absolutely.
And this is something that is very, very important, because without it, you may encounter significant challenges from the Immigration Service.
Yes, I'll add two things over there. One, exactly what Ignacio said. You can do what's called an interfiling after you've filed your application.
Yes.
And use that opportunity to meet the deadlines that Ignacio just talked about. If you said 3 months, get it done within 3 months. If you said 6 months, get it done within 6 months.
Yeah.
Don't look to buy time. This is not something that you do at your own discretion. Secondly, the standard of evidence is called preponderance of the evidence, which only means that you need to prove that your case is more likely than not. But in effect, in practice, the immigration, I think, has been looking for 100%.
Yeah.
So I tell my clients, unless you've given me at least 95%,
You're not filing the case.
I'm not giving you the green signal to wire the funds. And you cannot imagine, I think Ignacio and Aarushi sitting over here will agree, the amount of pressure the clients put on, why not? Give me this, give me that. It's unreal. And I think the reason why clients come to attorneys like us is because we are experienced, which also is equal to saying you have a lot of clients,
Correct.
which is also equal to saying you do need to wait your turn. There's no reason. You're not going to file a writ of mandamus against Ignacio or me and say, take my case out of turn and do it before everybody else's. Life just doesn't work that way. I think most clients are reasonable. Because I think we probably all may have gone through this. Haste makes waste. Sometimes we're all human beings. Sometimes things can go wrong when there's a gun held to your head and said, file it today. I don't care how. And then when something is amiss, it just becomes an issue for everybody. So I think we've got to keep all these, if you want to call them, soft spots in mind as you go through the whole process.
And also, sorry, Edwin, but just to add there that for all the viewers, filing a writ of mandamus to expedite the decision on your case, if your case is outside average processing timing, is a tool of necessity, not convenience. So I don't know of other immigration attorneys, but definitely none of us propagate this tool as just a pill that anybody can take. It should be with word of caution. You have to analyze the ability of your case to get approved. You must have all the evidence in place. In staggered cases, you must have ideally filed your supplementary application. So filing a writ of mandamus is helpful. I'm seeing that a lot of urban, high unemployment area project applications, which by itself take about a year to year and a half, get approved in 6 to 8 months. So it's a level playing field when it comes to urban and rural if you're filing mandamus. And that's great, but with caution for sure.